What are the rules for animation copyright and licensing? Imagine spending months creating a cartoon character only to find someone else using it without permission. That's why understanding the rules around animation copyright and licensing is so important. When you finish a cartoon, the moment it is fixed in a tangible form like a digital file or drawing, you automatically own the copyright. This protects your work from being copied or used without your consent. You do not need to add a copyright symbol or register it, but registering with the U.S. Copyright Office can give you stronger legal standing if someone infringes on your work. Registration allows you to sue for damages and attorney's fees if needed. Copyright covers the visual elements of your cartoon such as character designs, artwork, and storylines. However, it does not protect general ideas or themes. For example, you cannot copyright the idea of a talking mouse, but you can copyright your specific version of that mouse with its unique personality and backstory. Characters can be protected if they are distinctive enough, and courts have ruled that well-known characters are protected separately from the stories they appear in. This means others cannot copy your characters without permission. Licensing is how you give others permission to use your work under specific rules. For example, if a toy company wants to make action figures of your cartoon character, they need a licensing agreement. This document states how long they can use the character, where they can sell the toys, and how much money you will earn from royalties. Royalties are a percentage of sales paid to you as the creator. Licensing can also cover merchandise, video games, books, and even television broadcasts. Creating derivative works, like spin-offs or fan art, usually requires permission from the original copyright owner. Without it, you risk legal trouble for copyright infringement. Fair use is a limited exception that allows some use of copyrighted material for criticism, commentary, or parody. But fair use is complicated and depends on how much of the original work is used and whether it affects the market value. Trademark law is different but related. It protects names, logos, and branding elements that identify your cartoon source. For example, the logo of a popular cartoon series can be trademarked to prevent others from copying it and confusing consumers. Trademarks need to be registered with the government and are separate from copyright. Copyright and licensing rules can vary from country to country. If you want your work protected internationally, you may need to register in multiple places. International treaties like the Berne Convention make this easier, but local laws still apply. If someone uses your cartoon without permission, you can enforce your rights by sending a cease and desist letter, negotiating a settlement, or filing a lawsuit. Successful legal action can lead to stopping the infringement, damages, and even recovering legal costs. For creators, it's wise to always fix your work in a tangible form, consider registering your copyright, and use clear licensing agreements when sharing your work. Keep an eye out for unauthorized use and act quickly if you find it. When distributing globally, research the copyright and trademark laws in each country to protect your work. Understanding these rules helps you keep control of your creative efforts and ensures you are fairly compensated for your work.